Mr. Jelenic?
May it please the Court, my name is Roy Jeleno, Jr., and I represent the plaintiffs and appellants, Margaret and Richard Carey. For the reasons that follow, the rules for summary judgment, and more importantly, public policy, we suggest require that this matter be remanded to the Superior Court for trial, so that those who would contemplate organ and tissue donation of their deceased or dying relatives can be reasonably assured the donations will find their way to a useful purpose, to save or enhance the lives of recipients. To do otherwise will have a chilling effect on potential donors' families and will have the unintended and unfortunate consequence of suppressing rather than enhancing donation opportunities, to the terrible detriment of potential recipients and society in general.
Mr. Jeleno, may I ask you a factual question? I've taken a look at the consent form, and there's evidence that the practice is to read the consent form. I'm not getting to the issue as to whether or not this is an appropriate recording. Is there any claim by your clients that the consent form was not read to them? Have they ever so testified?
To my knowledge, they have not so testified.
And as I read the consent form, it says, and the testimony from the defendants was that is the practice to read it, the entire form when you're doing a telephonic, which would certainly be consistent with what one would expect to happen, is that there's a gift made to the organ bank for transplantation, therapy, or research.
I'm sorry, I didn't understand.
For transportation, therapy, or research.
Well, yes.
And I take it that the complaint here is, one of the complaints here is that this was only to be used for, if it could be used as a transplant, correct?
That's correct. That's our
So we have an undisputed record that says that this was for transportation, therapy, or research, as I look at the record.
I think Mr. Richard Carey's affidavit says to the contrary, that that he did not agree with this.
Well, I understand that, but he hasn't said that he wasn't read the form.
I don't believe that's correct. I agree with that.
It also says that the form authorizes the performance of all necessary tests and procedures, including testing for HIV antibodies, to determine, and there's some missed language because of the appendix, to determine the suitability of the organs and tissues for the purposes intended. Now, let's assume that it's limited to transplantation, but at least the consent form suggests to me that at the time the consent was given, there had not been a clear determination. I mean, he was agreeing to give a gift without a clear determination, recognizing that there might be some tests for which the organs and tissues could not be used.
That's what the form would say. I think that what this case is partly about is whether or not there was reason to believe at the time that this gift took place, there was evidence, information in the hands of the defendants immediately to disqualify the Carey son from donation. In other words, they had two elements. They had information that their son had been infused with saline solution that, with the use of a relatively simple calculation, told them that he that his body couldn't produce that test. And also on that same form that you just referred to, that there was no other pre-infusion sample available to otherwise conduct the test.
But it was also undisputed that the test was not conducted before the transplantation procedure began.
That's correct.
And where is the obligation to perform the test in the light of these very fast-moving events? Where is the obligation to perform the test before the transplantation, before the removal procedure?
Because it was a simple calculation. It was something that could easily have been done, and I'm sure that the justices have read the materials, but it was at least 8 hours from the time of the donation until the time of the harvesting. Certainly more than enough time to have done the calculation.
But isn't it also the case that if there had been some other blood test taken before the medical procedures commenced?
In this instance, it's my understanding that there was no such other test. This was a very sudden accident, and as I understand the facts, there was a very heavy trauma, and this young man did not have the opportunity to survive for a very long time, and all of the efforts, as I understand it, were to try to revive him, and I don't believe there's anything in the records that suggests that there was any other blood test available.
But what I'm trying to, I apologize if I didn't express my question correctly. What we're looking at is a statutory provision that provides a form of immunity for companies involved in these processes. Where do you say in this uniform statute is there a requirement that the transplanting entity conduct these tests before it begins to recover the organs?
Before it gets the consent.
Right.
I think it's in the statute itself. It says that you only get this immunity, this qualified immunity, if you can demonstrate that it's likely to lead to a useful donation. And I suggest that they have a fiduciary duty to conduct that test at the first opportunity to do that testing, and they had that opportunity.
But one of the points it seems to me raised implicit in Justice Cordy's question and in Judge Lowy's opinion is the timing issue. If we come out with an opinion that says if you don't assess suitability to a fairly high degree before you even request consent, then we're going to have endless arguments about, well, this disqualifying feature was in his medical record, but his medical record was this thick, and should the doctors doing it have seen this reference to this disqualifying disease or not? This is surely going to inhibit doctors from, they're going to lose a lot of potentially good donors because of the time constraints. And if they can't satisfy themselves about all the possible things that might make someone unsuitable, or if they fail to do that, they're going to risk being sued, then they're going to let go. That seems to be Judge Lowy's analysis, and what's wrong with it? It seems quite pragmatic and cogent to me.
I think that the problem with that analysis is that it suggests that there is no time, no reasonable time available from the time of the donation or the gift, in other words, the time that the consent is given, until the time of the harvesting. Hours pass here.
Right, but you were saying, your suggestion is they have to do this before they can go and ask for consent. I mean, time may elapse between consent and then harvesting or actual transplant, because until you get the consent, you're wasting your time lining up a harvesting team and a possible recipient and all the things that have to be done.
I guess I'm responding to your concerns about the impact upon on donations generally. In this instance, if I suggest that they could have done the calculation immediately, but if you want to argue that they needed more time, I would suggest that the consent that was given is conditional upon them meeting that standard that the statute calls for.
Mr. Gelanu, that's my concern. I mean, again, I go back to the consent form, and I see no challenge by your clients to what happened. It is a form. There are. It appears from its face that somebody went through very carefully through, each organ or other material, because there are no for some gifts that are not being donated. There are yes for others. There's a provision in the form that says we agree or we do not agree that those organs and tissues may be used for medical research, and it's very clearly indicated that the consent has been given. I agree that the organs can be used. I'm faced here with a summary judgment issue. And once you have the consent, there's nothing here that suggests that this is conditional. And indeed, one of the problems that I have with the case is that you suggest that consent was not given for use of the organs and tissues for medical research.
And that's my client. One of my clients says that he had the conversation that you suggest, but he says that the conversation was different than it was taken down by the person who took it down on behalf of the organ bank. And he says so in his affidavit, which is part of the record.
And so part of your complaint is that this conversation was not tape recorded, as it seems the statute requires.
Right. And had it been tape recorded, as we suggest that the statute requires.
Mr. Gelano, why doesn't the good faith provision define the way it is, which says really the defendants, if they're going to be held liable in a case such as this, have to act maliciously, unconscionably, fraudulently? Why doesn't that cover all of this? There's absolutely no proof as to the taking down of the consent, as to the hemodilution, if I'm saying it right, testing, any of the other things that they acted any other way other than good faith.
Again, I think it's a qualified immunity situation, and the statute calls for specific things to be done.
Where is the evidence? What evidence do you have of bad faith? That they acted maliciously, arbitrarily, strike arbitrarily, maliciously, fraudulently, or unconscionably?
I suggest that by being reckless in their approach to the situation, that is not good faith, and that denies them the immunity that the statute suggests otherwise.
So there is no specific factual data, however, that from your folks that show any bad faith.
Well, I'm saying that if you look at their conduct, and as I'm sure you're aware from reading the briefs, that it's in the totality of the situation, all of the things that happen in this situation, from the moment when they failed to properly tape record the conversation, all the way to the letter that was sent post recovery when they knew that or should have known that the boys' remains couldn't be used, all the way to the meeting months later when, rather than be aware of their files or not being truthful about their files, knew that the boys' remains had been discarded and failed at that meeting to tell the Careys, and then subsequent to that told them that within days of all of this, the boys' remains had been incinerated, contrary, by the way, to the statute, which calls for, I suggest, once they determined that they couldn't use this material, that the Careys should have had an opportunity to bury those remains with the rest of his body, as their faith would suggest.
On what basis do you conclude that there has to be a tape recording, an audio recording?
In the statute, it suggests that...
Could you point me to the particular language?
In the statute?
Yes, please.
In the statute, and I'll try to find it quickly, it states that ironically, the New England Organ Bank's rules and regulations, and this is in 113...
10E.
No, I understand.
Subsection B. Shall be by document or by telegraphic, recorded, telephonic, or other recorded message.
What's other recorded message?
You asked me that, Judge. Justice, other recorded message, I suggest, would be, for example, they could have taken the consent form by facsimile, sent it back to Mr. Carey, and allowed him to review the document.
It doesn't say that, though.
Well, you asked me what are the,
The judge thought that they complied with that provision, but he skipped over it and said the good faith provision takes care of it anyway, because they weren't acting in good faith, in bad faith, rather, when they did it the way they did it. Right?
I think he did, and I suggest that was
that's what he
error,
did.
obviously.
Well, that's why I asked, because at least if you go to Justice Glaney's question of the good faith, you said from the very beginning they didn't comply with the statute. It is not at all apparent to me that they didn't comply with the statute. They have a written record with two people on a telephone having conversations. And there's nothing that says it has to be signed by the donor.
If I may, Justice, again, we point to the organ banks. They set the standard. Their standard calls for a tape recording. It says on that form, tape number inside and so forth. And I suggest that is their procedure. They didn't follow their own procedure. That procedure is the one that the statute contemplates, and they failed to do it.
Thank you, Mr. Gianno.
Thank you.
Ms. Gilman?
Good morning. May it please the Court? My name is Pam Gilman, and I represent the New England Organ Bank.
If we agree with the judge's interpretation of good faith, which appears to have been defined by a bunch of cases in other jurisdictions, including Nicoletta, doesn't that pretty much take care of everything?
It does, Your Honor. The good faith standard is a formidable one, as decided by Nicoletta almost 20 years ago. It requires dishonesty, maliciousness, fraudulent activity.
Isn't that a definition of bad faith? And I mean, there is, in my judgment at least, a difference between good faith and bad faith.
The distinction is...
The Nicoletta relies on good faith and a pretty good Black's dictionary of good faith, correct?
It is correct, and a lack of good faith would be a lack of honesty. And since the rest of the definition is an absence of malice, an absence of a design to defraud, therefore you would have to find the positive of that, or you would have to find a malicious conduct, a design to defraud, or a design to seek an unconscionable advantage. That would then put it as a lack of good faith, if you were to take that definition.
And why isn't
the
that...
only reason why I say that is because it may not appear they're not identical, but it seems to me that good faith really is focusing on some very particular pieces of what it takes, and particularly when you're dealing with professionals in this context. And so, for example, a claim that, as is in this case, that because you're a for-profit versus a not-for-profit entity, I don't think is implicated in a good faith definition.
I understand, Your Honor, and it would be our position that unless there's any evidence of a lack of good faith, then that immunity applies.
Well, what about, ordinarily, good faith is a question for a jury to decide.
That is correct.
And you say there's lack of any evidence, well, there is no evidence of lack of good faith. If, in fact, your client did not comply with the statute, why isn't that evidence of lack of good faith? Failure to comply with very clear statutory guidelines.
As Judge Lowy found, if we were required to comply with the statute, it would render the immunity absolutely null and void. What we have to do is have a good faith effort to comply with the statute, and that's exactly what we did.
And is that what the statute, is that what that section says?
The section says that any person who acts in good faith in accordance with the terms.
In accordance with the terms. So still, there are many actual cases in which the individuals have acted in accordance with the terms, but there's a misunderstanding. And this eliminates misunderstandings as being the basis for lawsuits or negligence. But don't you still have to sort of act consistent with the specific requirements of the statute?
It's our position that we did act in compliance with the statute, and if we didn't, there's no evidence that we failed to do so with a lack of good faith.
Now, And you say there's no disputed material issues of fact?
That is correct. That is correct.
What about, Mr. Carey's affidavit, I take it, suggests that the consent conversation that he had gave certain limited consent. Conversation wasn't tape recorded, so we don't have original evidence of that. And yet the actions of your client were inconsistent with that consent. Is there evidence that the actions of your client were inconsistent with the consent that Mr. Carey says he gave?
Well, Mr. Carey, in the after-the-fact affidavit, says that consent was given for a limited purpose.
Well, most affidavits are after the fact.
After the filing of all of the various material.
Was he deposed?
He was deposed, and what his deposition testimony was contrary to the affidavit. That's what I meant after the fact. He previously testified that consent was given consistent with the consent form. But
I was trying to find that. I don't think that piece of the deposition is in the...
It is not, but the recitation of the questions, which is on page 180 of the plaintiff's deposition, is actually in the transcript of the hearing, which is an addendum to our brief. And the questions that were asked of Mr. Carey at that time with respect to his consent are in that hearing.
Well, what you're calling a so-called after-the-fact affidavit, haven't we said that for purposes of summary judgment, you can't consider an affidavit that is inconsistent with your prior deposition testimony?
This Court has said that.
So that affidavit would be of no value.
That's
so then the only evidence would be that he signed the consent form, or his deposition testimony that he gave consent consistent with the consent form.
That is correct. And as a practical matter, if we were to say that any plaintiff can then say, after the consent form is read to them verbatim, signed, witnessed, with very clear language contained within that form, any plaintiff can say...
Not signed by the plaintiff, though.
Excuse me?
Not signed by the plaintiff.
Not signed by the plaintiff, because it's not possible physically in most situations to have it signed by the plaintiff.
But one way to satisfy the requirements is to have it signed by the person giving consent. Another way is for a telegraphic, a recorded telephone, or other recorded message. Those are the methods.
Correct.
To ensure that these kinds of confusions are not there.
And if it were tape recorded, we wouldn't be here. And if other conversations were tape recorded, the vast majority of the other cases where there's confusion about the consent wouldn't have been before those courts.
So why don't you tape record? Isn't it the procedure to tape record? I mean, even the form itself sort of suggests
it wasn't at the time. It wasn't adopted at the time.
What was
New
it?
England Oregon Bank did not have a tape recording procedure at the time. They were contemplating it. It was put in the form, but it hadn't yet been begun to be used.
Could I just back up? Is it your contention that the factual dispute about whether particular organs were not within the scope of consent is taken care of by this deposition testimony confirming the accuracy of the version of the consent form that was read?
The factual dispute, well, I'll have to backtrack because there are a couple of questions which the plaintiff has raised in his affidavit. One is that he did not consent to research. That is something that came up new in the affidavit.
I thought there was something about the harvesting of certain organs, I think it had something to do with the heart, that were not included, the plaintiffs say were not included within the scope of which organs they consented to.
Yes, there were two. Harvesting of the AI, which is the aortic iliac vein. Plaintiff says he did not consent to that.
That particular one was added. That's not a printed part of the form, correct?
That is. That's because it requires a different incision. When you take the femoral and saphenous veins, that's an incision in the groin and leg. When you take the aortic iliac, it requires an incision in the abdomen. That's why, at an abundance of caution, the New England Oregon Bank has it as a separate area in the event that that is something that can be retrieved, depending on the nature of the trauma, so that they make sure that the families understand that that would be a separate incision.
All right, but was this also covered in the form that was read to him over the phone?
It was.
His deposition said, yes, that's what I That was read to me, and that's what I agreed to.
I have to concede that I don't recall whether or not the specific question was asked of him at the deposition about the
But it is on the
aortic
form.
iliac
I haven't
vein.
looked at all the- okay.
Correct, it is on the form,
That's
and it
what
was
I
read to him verbatim.
Well, were those organs actually harvested? The ones that are now, Mr. Carey now claims he never consented to their harvesting?
Only the aortic iliac vein was harvested. It was ultimately discarded because of the hemodilution problem.
And
It
were
was, in
any
fact,
were any of the organs that were harvested used for research?
No.
Thank you.
Thank you.
Mr. Sullivan?
Thank you. Brian Sullivan on behalf of the New England Eye and Tissue Transplant Bank, which, as the court is familiar, is the Boston office of Tissue Banks International, a corporation down in Baltimore, Maryland. It is, in essence, the successor organization of what had formerly been known as the New England Eye and Tissue Transplant Bank. If I may, of course, I support my sister's arguments wholeheartedly. I would like to take a moment, if I could, and review the position of the New England Eye and Tissue Transplant Bank with respect to the record before the court. That is in no way meant to attempt to distance myself from the organ bank. We fully support the organ bank. The record does show the court that, in addition to the arguments and the issues that have been discussed this morning, the New England Eye and Tissue Transplant Bank was notified by the organ bank about the donation, and that the New England Eye and Tissue Transplant Bank then sent its team to the Office of the Chief Medical Examiner to proceed with the recovery. The record before the court also demonstrates that at the time that the New England Eye and Tissue Transplant Bank got to the medical examiner's office, the medical records from Salem Hospital were not available. The record shows that those records were then later faxed from the medical examiner's office to the offices here in Boston of the New England Eye and Tissue Transplant Bank, and that 2 days following the recovery, an employee by the name of Kimberly Cook, collecting the tissues and preparing them for processing and distribution, reviewed the records and determined that there was a hemodilution problem. Ms. Cook then contacted the New England Organ Bank, and there's a form in the records from the New England Organ Bank that has a notation 9/18/2000 per New England Eye and Tissue Transplant Bank, there's a hemodilution problem, and let them know about the issue. There's also information in the record that demonstrates that the New England Eye and Tissue Transplant Bank then undertook a course of action to try to locate a sample. I'm raising these points in further discussion of the question of good faith.
Aren't you covered by good faith, too?
We are, Your Honor, and it's our position that the record on these points supports and can only support the determination that we were in good faith.
If the New England Organ Bank is found to have acted in good faith so that it qualifies for the immunity, you automatically are covered by that.
I would certainly agree with that position, Your Honor. I'm reciting the facts in an effort to bolster the information available to the court and the discussion on the fact that we were acting in good faith.
And are there any facts, to your knowledge, that would, under the standard, have looked at most favorably to the plaintiffs, cut against this good faith?
Our position is certainly that there are no facts developed in the record and that there are no facts to develop which would undercut the position that the New England Eye and Tissue Transplant Bank was proceeding in good faith with the recovery.
Could you just address the statutory question and without not directly address to the facts in this case, but I take it that a good faith attempt to comply with the statute is implicit in the so-called objective test. In other words, what the courts around the country seem to be saying is the legislatures have defined what the appropriate conduct should be, and as long as you, as Ms. Gilman said, make a good faith attempt to comply with that, you benefit from the immunity provision, correct?
Yes, Your Honor, that would certainly be our position.
So I take it that there are all kinds of entities out there, including your client, that is trying to make an attempt to comply with the statute. As a general matter, do you know whether or not two people listening in and somebody recording on a form and then using that as the basis of consent complies with the statute I take it's your position that it does.
It is our position that it does, and if I may take a moment to address that. The cases which have been cited in the brief seem to have sort of an array of different situations. They have family members in the hospital signing consents. They have family members on the telephone with other persons. Some of them discuss a recording. Some of the cases don't reference a recording. They have situations where one institution, such as in this case, discusses a donation with the family. They then contact another institution. In fact, as you look at the cases, quite a few of them involve that particular situation. And like in this case, where that occurs, we are in good faith compliance with the statute. And
Your client didn't get the consent.
That's correct, Your Honor.
You had no role in the getting of the Carey's consent.
That's correct, Your Honor. We did not.
But I take it from this that if we were to suggest that you have to have an audio recording, that would have a dramatic impact on the capacity of institutions to obtain gifts where people fully intend to do that, right? Sometimes it's in a hospital. Correct?
Yes, Your
Sometimes it's
Honor.
over the telephone where there isn't access to a tape recording.
We would certainly suggest it would inevitably have an impact. In addition to that, it would be adding to the statute as it now stands. And our earlier discussion about good faith compliance and an attempt to comply with the statute in good faith, you would have situations where if any arguable issue on statutory compliance that didn't demonstrate a lack of good faith were the subject of litigation, the whole purpose of the Uniform Act would be defeated.
This was a Uniform Act, correct?
Yes, Your Honor,
and
it was.
have you looked at the, the commentary that usually goes with such as to what the meaning implicit in or intended was under Section 10E?
Your Honor, we would suggest that in the briefs there are cites to the cases which discuss particularly the intent of the Uniform Act. I believe that that citation is to the commentary, and that the purpose of the Act, of course, is to facilitate
No, I know that. I mean, specifically with respect to 10E, what the drafters of the Uniform Act intended what they meant by the language in 10E, which is either you get a document signed by the donor, which is problematic anyway, or made with a telegraphic recorded telephone or other recorded message.
I do not have a citation to a comment on the purpose in 1968 when that was initially put together. However, from the text of the statute, the term other recorded message seems to support the facts in this case, which is a record of the discussion, albeit not a perfect record because it's not tape recorded, but as Ms. Gilman pointed out, there are many situations where it might be perfect to have a tape recording, but we just don't for some of the practical considerations that the Chief Justice is pointing out.
Let me ask you this. If, going to the issue of good faith, if there was evidence that the representative of the donor, the person authorized to give consent, said, I'll consent to a transplant but not to research, the person on the other end of the phone says, no, that's not a problem. So he gives his consent, and then, in fact, the organs are taken for research purposes, and the parents are sent a letter saying, and we transplanted the organs, falsely says, and we transplanted the organs successfully, so we really appreciate everything. Thank you. Isn't that this case?
It is not, Your Honor, for this reason. In this case, what the record discloses, and I take it that the Justice's references to the letter, the records in this case demonstrate a letter was sent in error. That was explained by both written correspondence to the family and in the course of a meeting, and there's nothing that rebuts that. So I guess the key to the question would be...
Well, there's nothing that rebuts it. What you're saying is that months and months later, apparently after the plaintiffs made a series of efforts to determine where the other tissues were, and I'm not quite sure what all the facts are there. I haven't really focused on the entire record. They discovered that there was a problem here that they hadn't been told about, and it was their efforts that led to this the New England Organ Bank saying, sorry, big mistake. That was an incorrect letter.
Your Honor, we would...
It wasn't like they got a letter and then the next day or a week later or 2 weeks later said, we've made a terrible mistake. That letter was sent in error. It was only after the plaintiffs really pushed and conducted their own inquiry that this apology came forward.
The plaintiff's complaint, Your Honor, implies that when they got the letter, they called the institutions and then learned during those phone conversations that the hemodilution problem had arisen. This was within a matter of weeks, and it was within a matter of days, presumably, of the Careys receiving the letter. That is in the body of the complaint itself, which is contained several places in the exhibit.
And were there any efforts made to try to get to the bottom of this? I mean, but it was 6 months later that a letter came saying, an explanation came.
Your Honor, it was 6 months later that a letter came. It was also sometime later that a meeting was arranged, but there were a series of conversations, and the Careys in their own complaint say when they called, that's when they learned.
So there was no evidence that this was an intentional lie to cover up the use, the intended use of the organs for research, which the Careys say they did not consent to.
No, Your Honor, there's no evidence of that. In fact, the evidence in the record is that it was in error, and that was contained in several exhibits in the record, including the deposition testimony of Mr.
I take
Buckley.
the tissues, none of the tissues was used for research.
That's correct, Your Honor. None of the tissues that were recovered, in addition to that, the New England Eye Bank
They were found
recovered.
unsuitable for transplantation and discarded.
Yes, Your Honor, the New England Eye Bank recovered tissues which also were, by the Carey's own admissions, part of, even by their version of events, anticipated to be recovered, and they were discarded.
I have one question for you. I'm just curious. How complicated is it to determine whether there's a hemodilution problem?
Your Honor, what I would suggest is that, looking at even this record, on Ms. Cook's notes, and that's at page 473 of the record index, even then, on the 18th of September, 2 days later, Ms. Cook is discovering additional information which wasn't immediately available. She discovered an additional 700 cc's of fluid that had been administered. Now, I understand that that goes to a greater hemodilution problem. The point is that it is a little too exacting to actually expect that this perfect information flow, when 2 days later you've got someone at the New England Eye Bank who's still discovering more information. In addition, Mr. Buckley's deposition testimony is that this is not an infrequent occurrence that they later find a pre-infusion sample. In fact, that's really what underlay the efforts of Ms. Cook to do just that. That's also contained on page 473 of the record, where she's calling Salem Hospital. She's calling the laboratory. She's calling the blood bank. There's 2 separate phone calls. I believe the names are even recited in there, all in an effort to find a pre-infusion sample. Mr. Buckley has also testified, and this is in the record, that in his experience in this business, he can think of maybe 10 or so times when a donor, unfortunately, has been, 1, both hemodiluted, and 2, later efforts did not retrieve a pre-infusion sample. So this really is an unfortunate occurrence, which happens from time to time, but is certainly not outside the realm of the reality of dealing with collecting tissue and getting consent in the immediate aftermath of a tragedy such as this.
Thank you, Mr. Sullivan.
Thank you, Your Honor.